The next matter to come before the court this morning is State of Ohio versus Jason M. Johnson. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve that time, if you let me know when you get started on keeping the clock this morning and keep you apprised of the passage of time. The court's read the briefs and we're ready to see when you are.
May it please the court, my name is Richard Cassay, representing the state of Ohio in this state appeal. The issue in the appeal is whether or not Mr. Johnson had a conviction for DUI on September 6th of 2000 in the Akron Municipal Court. The state introduced two exhibits at the hearing. Exhibit 1 is the certified DMV driving record for Mr. Johnson, and he agreed that that was in fact his record. The pertinent page is page 7. I believe there are two codes on that page that reference the pertinent case number and the pertinent date. Code 061 is a DUS, driving under suspension. Code 062 is an OUI. The DUS code indicates that there was a plea of no contest in that case number on that date, September 6th of 2000. 6 points assessed. The code for the DUI, which is 062, again, same case number, same date, plea of no contest, no points assessed. Now, one of the issues at the hearing, and in fact there was a considerable amount of cross-examination devoted to this, was that, well, you have a DUI and you have no points. How can that be? Because everybody knows that DUI is a point offense. Well, it's very simple. The former statute provided that when you had traffic offense, DMV is going to assess the highest number of points. When there are multiple traffic offenses committed, it's part of the same transaction, course of conduct, at the same time, however you want to term that, and the points for one or more offenses are equal, then you assess for one of the higher point offenses. In other words, if you have a DUS and a DUI, you do not assess 0 points, you do not assess 12 points, you assess 6 points. And that's what happened here. And that was the testimony of the hearing, that sometimes they'll put points on this one or sometimes on that one. That does not take away from the validity of the exhibit as showing conviction for DUI on September 6th of 2000. The state also introduced its Exhibit 2, and this was what Mr. Johnson rebutted, and I'll get into his rebuttal evidence in a minute. I don't know if I reserved any time.
You did not.
Then I didn't. That's fine.
Yeah, but you may.
No, that's all right. Thank you, though. I didn't remember. State Exhibit 2 is the internal records from Akron Municipal Court for that particular day, for that particular case number. 3 charges: DUI, DUS, minor misdemeanor, assured clear distance. What that exhibit shows, to the state's belief, is a sentence on the DUI and the DUS. DUI, 180 days, 170 suspended, 10 days MOP. DUS, 10 days SMF, 10 days MOP. there's a fine of $850.
On the DUS?
It says fine $850.
Oh, okay.
Now, just talking about the DUI, the way the statute was, and I think it still is, for first-degree misdemeanor, minimum sentence, 180 days. Maximum sentence, excuse me. When there is a prior offense, and the exhibit showed a prior DUI conviction in Stowe Municipal Court, the minimum term of incarceration or confinement is 10 days, and that's what this exhibit shows. 10 days in MOP. And the fine. So that supports, in the state's view, what the BMV exhibit reflects. And there was testimony that, well, BMV is only as good as what the courts give us. So good information in, good information out, garbage in, garbage out. So here's what the internal records show. Now, during cross-examination of the clerk supervisor, Mr. Johnson said, well, wait a minute, we have an exhibit too, we have an exhibit as well, Defense Exhibit A, and it shows, and that's part of the record, no doubt, part of the internal records, for the DUI, guilty dash plea to reduce charges. So Mr. Johnson says, well, wait a minute, he cannot have been convicted of a DUI because this shows guilty /plea to reduce charges. The clerk supervisor said that is, at least in the year 2000, what Akron Municipal Court used to reflect that one of the charges was reduced or dismissed. That same exhibit shows the minor misdemeanor, assured clear distance, was dismissed. Now the trial court had a big problem with this. Incomprehensible, I hope he was mistaken. She didn't say he was mistaken, but I don't understand why a court would do this. Well, the state submits that doesn't make any difference. The Akron Municipal Court does not have to devise a procedure that a court of the General Division of the Common Pleas some 15 years later thinks is what should have been done.
But the witness does have to testify to something that is, that the prior fact regards as logical. So you could say that the words here say, this defendant pled guilty to reckless operation, which was reduced from DUI. I'm just making this up.
Mm-hmm.
And then you could have an employee of the clerk's office come in and say, yes, that's what this says, but it really means the opposite. And so my point is that the trier of fact doesn't have to credit something that does not comport with reality.
No, if the clerk supervisor came in and said something that does not comport with reality, I would agree with you. I would disagree with you, Your Honor, that the clerk supervisor has to say something that the General Division judge thinks is logical. It doesn't have to strike the judge as logical. He said that's what they do.
Let me ask you a question. When you're saying this guilty plea to reduce charges, he was
Charge.
initially charged with 3 things.
Right.
And he pled guilty to 2 of them, and one was
Dismissed.
dismissed. So the reduced charges, there was 3, now there's only 2.
Yes.
We're not saying he pled down the absurd clear distance to a reckless act. I mean, that's not what we're saying. He didn't reduce one of the charges down to something else. He reduced 3 to 2, right?
there were 3 charges reduced to 2. Now, the way I tried to look at it, well, this is striking you the same way it struck Judge Davis, but that does not make any difference, Your Honor, with respect. There was 1 charge, 1 unitary charge, now 3, now we have 2. And it doesn't say, it says pled guilty, plea or pled to reduce charges. It does not say that the DUI was reduced to anything. The exhibit shows, in the state's view, without a doubt, that it wasn't. What's 180 days and 10 days in MOP and an $850 fine? That's not a reduction to I'm sorry, I'm interrupting you.
That's okay, I understand you. But let's back up to what the statute says in terms of what the state needs to do when we're trying to elevate an OVI offense based on priors.
Right.
So the state would be able to come in with the BMV record.
Which they did.
Which they did, and then in addition you had an expert from the BMV testify regarding that particular record.
Right.
And then the defendant would be able to rebut, hey, that's not me, and here's why. I mean, there are specific directions in the statute as to what the defendant does next if he believes that the state has the wrong idea about what his criminal record, or driving history is, excuse me.
Yes.
Okay. How did we get to the point where someone is testifying on behalf of what the Acton Municipal Court documents? Is this a rebuttal witness? Is this one of the state's witnesses? I'm trying to figure out where in the timeline we get to that witness's testimony.
The clerk supervisor was called, I'm going to call it in the state's case in chief. That was a state's witness. The defendant, Exhibit A, came up during cross-examination, and then it was admitted as a state exhibit. Now, let's say that the state had only put in Exhibit 1. BMV record, he said it's his, there it is, no contest DUI, no problem. He's still going to put in that Exhibit A, because he wants that is Mr. Johnson's whole case. Plea, or guilty / plea to reduce charges. That's it, that and the no points. The no points in the state's view goes nowhere, because we know why one was 6 and one was 0, because that is what the law required. So he's got to get in this plea to reduce charges.
So, but the state brings it in
The
first.
state brought the exhibit in first, but if we had not, I wasn't there, Judge, but I am strongly suspecting that there were some discussions prior to this hearing. The prosecutor says, we got this. Defense counsel says, we got that.
Well,
Sorry.
I'm not trying to imply that the state had acquiesced anything after the first exhibit, or I'm just trying to get at how we got there.
That's how we got
You
there.
explain.
Yes.
And I want to go back to the statement that you just said, and the reason that strikes me as curious is because as I read the briefs, it sounded as if when the defense was cross-examining the state's witness, it asked, is this the entire record?
Mm-hmm. Yes.
And the witness says, yes, this is it. This is the entire record.
That was a mistake.
Well, and so that kind of cuts against, everybody got together and knew what the other was going to submit. Because then the defense said, well, wait a minute, what about this that says there was a reduced charge?
Well, maybe it does and maybe it doesn't, because I think your point would presume that the prosecutor talked to the witness beforehand. I think that would be how that would play out. Again, Judge, I wasn't there, but that's how it played out. The clerk supervisor testified for the state, and then there was no testimony that I recall from from Mr. Johnson, his defendant's exhibit A was submitted.
So it's your contention, Mr., to say that the most number of points that could have been assessed in this case is 6?
Absolutely,
You couldn't have assessed 12, 6 on each on the DUI and 6 on the DUS. 6 was the most you could have gotten.
absolutely.
And it had to be assigned either one charge or the other
It
charge.
doesn't make any difference because they're both 6-point offenses.
Okay.
Pick one. Yeah, there's 12 points could not have been assessed because this is one incident resulting in 2 6-point offenses. And that's, I quoted the statute, 6 points, they're both the same. Could have been 6, could have been 4, could have been 2, you don't double up. Now,
12 seconds.
12 seconds, I'm done, thank you.
Okay.
Thank you, Your Honor. May it please the court. My name is Tom Houlihan. I'm here on behalf of the appellee Jason Johnson. I'd like to start with the last thing that was discussed, the issue of whether or not the BMV records showing no points is important at all. And in our view, it's very important. One of the reasons why it's important is because every single witness that testified at the suppression hearing had never seen such a thing before. So while the representation has been made in this appeal, you just pick one, you put it in, 6 points here, 6 points there. That's not the way that these witnesses, any of these witnesses, are used to seeing this information, which led to significant questions about the reliability of the BMV report. Pursuant to the statute, the parties can go beyond the scope of the BMV report, it's rebuttable evidence, and look to what really happened in the underlying court case. Here we're hampered because the Akron Municipal Court did not preserve the judgment entry. That is what would have been required for the other branch of the statute to prove what this offense was under the guidelines of Civil Rule 32 in State v. Gwynn. There has to be a signature, there has to be a timestamp on the judgment entry that imposes sentence and conviction. We don't have that, so all of this is supposition and guesswork, and that is the problem here. We have gone down all of these roads into what the Akron court documents mean, when ultimately it doesn't matter because they are unclear and self-contradictory, as the trial court found. And that propagated itself into the BMV report, which is also inconsistent with what everybody seeks and everybody expects to see. The testimony at trial from the BMV supervisor was, we just report what the trial court gives us. That's what she said. And that's what we have here is mistakes on the BMV record because the Akron Municipal Court did not preserve the underlying records. Now, Judge Schaefer, you asked about the issue of the guilty plea to reduced charge. And I want to point out in Exhibit A, Defendant's Exhibit A, there are pages that go to each of the 3 original charges. They are denominated at the top by a 001, a 002, or a 003. If you look at the 6th page of the exhibit, under count 1, which is the DUI count, that is where it says guilty plea to reduced charge. So the explanation by the court clerk administrator...
On count 1?
What's that? On count 1, yeah. Was, no, that doesn't mean anything about count 1, the DUI charge. That means that count 3 was dismissed. Well, that doesn't make any sense. Respectfully, it doesn't make any sense. And that's what the trial court found here, is the explanation didn't make any sense. The trial court could not tell what happened on at the time of the September 6, 2000 conviction. With that sort of inconsistent evidence, how can the court just hand it off to a jury and say, go figure it out? It's not constitutional. It's a violation of due process. And the court in French and the Hubbs case, which we cited in our brief, encouraged the courts to handle these things in a pretrial capacity. Now, obviously, you're commonly seeing motions to suppress as illegally seized evidence and those kind of issues. But specifically in French and Hubbs, these sorts of issues regarding matters that are prerequisites for conviction under the DUI statutes are handled as motion to suppress issues. So the court didn't exceed their jurisdiction. The court said, this is a mess. We can't tell what went on here, and correctly suppressed the evidence. So in that regard, unless the court has questions for me, I'll rest upon that representation. There's no way the judge could send this to the jury to figure out, because the judge couldn't figure out what happened here.
Can you speak to the issue of that was raised regarding the state's appeal and whether it included both the dismissal of, am I on the right case?
Yes, you are.
Oh, okay.
There was a motion to suppress and a motion to dismiss filed in the trial court. The motion to suppress was as to the evidence of 5 prior convictions. The motion to dismiss was a motion to dismiss just specification 1. Under the statute, specification 1 was a sentence enhancement because he had 5 prior convictions under the theory of the state. The theory that was presented in the motion to dismiss was based upon the Klimbus case out of the 8th District, that it was an equal protection violation to charge him with both. The court did not resolve the Klimbus argument, but did grant the motion to dismiss specification 1. When the state filed its appeal, the state specifically said that it was appealing from the judgment entry granting the motion to suppress entered October 16, 2014. In this court's prior precedent, the Buckeye Union case that it's cited in our brief, it's clear that if one specifies just a portion of an order to be appealed, the remaining portions of that order are not appealed. So in our estimation, since the state did not appeal the granting of the motion to dismiss specification 1, even though it was on grounds other than what we raised in our motion, that issue is done, and it's not on appeal, and it's final. And the only thing that we're here about is the motion to suppress.
Let me ask you a question.
Sure.
You stated that nobody from the BFV had ever seen 0 points on a DUI before. Had they ever seen 0 points on a DUS before?
I don't think that question was asked, and the testimony was from 3 different witnesses,
Okay.
both the police officer, who sees those all the time, the BMV operator, and the court clerk from Akron Municipal Court.
And if Mr. Johnson hadn't been convicted on the DUI, then what would we have allocated that 180-day sentence with 170 days suspended and the 10 days in the multiple offender program? What charge would that penalty have been attached to that if it wasn't a DUI?
I don't know, and that's part of the problem, is there was no testimony on this issue or discussion of this issue of what the MOP means and those kind of things at the hearing. So I read the transcript and I make the arguments, and I'm learning about MOP and what that means from the appellate briefs, which is not how it's supposed to work. So I can't answer that question because I don't know.
Was there any testimony from the officer or anyone with respect to the BMV's records not always being in line with judgment entries in terms of the assessment of points?
The BMV supervisor's testimony itself was, we're a pass-through, we report what the court reports, we put on what the court tells us to put on. That was the testimony. So the testimony from the BMV operator itself was, it's dependent upon what the court reports to us. And here the court's internal records are troubling, to say the least. And you look troubled by that response.
I'm only troubled because it's dependent on what the court reports to us is maybe not, and I didn't ask the question of the BMV person, but it's maybe not responsive to the inquiry as to when they're doing their record keeping and they're putting points on the record from which other things flow. What the court gives to them, I don't know to what they're referring. Is it the offense and then they know that certain offenses carry certain penalties and so they assess the points, or are they looking at the judgment entry?
Page 38 of the suppression transcript, the BMV supervisor testified. The court says, this makes no sense to me. It is that a driving under suspension is 6 points. In your experience, have you seen that? The witness, I believe it used to be 6 points and now it's 0. But again, it's whatever the court reports. So if they want 6 points on the driving record, then that's what we will put on. So I don't know if that answers your question, but that was the testimony on that point. All right? Thank you, Your Honors. If there's nothing further, I'll go ahead and sit down.
Thank you both for your presentations this morning. The court will take the matter under advisement, which will issue a decision, which will be mailed to both sides, as well as posted on our website and the Ohio Supreme Court website.
Thank you.